John Pete Minot for the University of Hawaii Hilo. We're here today, right, okay, get that. I'll try to get it right. We are here today on behalf of the state of Hawaii's highest institution for education and learning, and to seek your approval for a CDUP to allow construction of the 30-meter telescope on Mauna Kea. There should be little doubt about the importance of this project to the scientific community and keeping our state at the forefront of astronomical research and higher education worldwide. The TMT project will advance scientific knowledge, provide jobs, economic benefits, and educational opportunities, and it will do so in a manner that is sensitive to the important cultural concerns that makes our Hawaiian state so unique and treasured. The university has presented significant evidence in the contested case hearing, as confirmed in the hearing officer's findings, that this project does satisfy the 8 criteria to approve the CDUP. The hearings officer's findings clearly detail how each of the 8 criteria are satisfied. The main areas of concern can be summarized in 3 main topic areas: cultural considerations, management of the mountain, and mitigation efforts designed to address any impacts. For cultural considerations, the obvious start point is with the significant evidence introduced to satisfy the 8 criteria during the long 4-month hearing. From those proceedings, the board now has a large inventory of cultural information for this project that has been collected since at least 2009. This is contained in the Cultural Impact Assessment, the Environmental Impact Statement, consultations during other permit processes, and now through this extensive 4-month-long contested case hearing. Cultural concerns have been given a full and complete opportunity to be presented by various interested persons. The information contained in the extensive record for you to consider to satisfy your obligations under Chapter 91-11 is extensive and broad. For Kapa'akai purposes, you would be hard-pressed to find any other project in the state of Hawaii that has gathered such an extensive inventory or survey of cultural practices, and that also analyzes the impacts of the project and addresses mitigation efforts to the extent feasible. On the issue of whether the TMT project would infringe unreasonably on existing traditional cultural practices, for this petition area, there are no traditional or customary practices proven to exist in the 5-acre footprint and 3-acre access way. Importantly, the law does not protect religious belief over how the state land should be used, but instead applies to actual practices. For this project, there are no historic properties or religious or cultural activities proven to have taken place over time in this 8-acre TMT project location, and certainly not before persons who have protested this project constructed Tu'ahu on the access roadway in 2015. No pre-existing traditional practices will be halted by building this project on the 8-acre Northern Plateau location, which is well below the more sensitive Summit Ridge area. Cultural practices will still be honored and allowed to proceed in the Summit Ridge areas. After a thorough and complete Kapa'akai analysis, nothing should prevent this board from granting the CDUP subject to the proposed conditions that fulfills the board's special obligation to protect Native Hawaiian rights. The second area of emphasis is management by the university. The university is continually striving to improve its management of the mountain. Over the past 20 years, the university has taken many concrete and measurable steps to fulfill its obligation to improve management. Among those steps have included the adoption of the 2000 Master Plan, shifting primary responsibility for mountain management to the University of Hawaii Hilo and the creation of the Office of Mauna Kea Management. Also working with the Land Board to implement the Comprehensive Management Plan, the Cultural Resources Management Plan, and the Natural Resources Management Plan, along with the Public Access Plan and ultimately the Decommissioning Plan. The UH is also committed to implement Governor Ige's 10-point plan. UH has engaged with OHA and other groups on management and operational issues. Most recently, in keeping with the 10-point plan, the Board of Regents resolved to support collaborative efforts and return 10,000 acres to the DLNR. The university stewardship will be in part governed by the CDUP and conditions imposed by you as part of this approval process. Those conditions will supplement the already existing board-approved management plans and will guide the university towards better management of the mountain. The university is continually striving to improve its management and intends to carry through depending on what conditions are imposed in this permit. The third area of emphasis is mitigation. The existing uses in the astronomy precinct are undeniably astronomical facilities. Those facilities are specifically authorized by law in a conservation district resource subzone. The proposed use here is certainly consistent with existing astronomical uses in the 525-acre astronomy precinct. The TMT location on the flatter slope area of the northern plateau, referred to during this case as Area E, was part of the ongoing concern for cultural issues as far back as the 2000 master plan. That plan identified Area E for the future Next Generation Large Telescope, and it is beneath the culturally more sensitive Summit Ridge area. As part of the evolving effort to consider how to address and reduce any additional impacts by the project, significant steps were taken in design to reduce the size, shape, and configuration of the telescope building. The natural resources that will be utilized by the facility include the high elevation, clear sky, favorable humidity, minimal light interference, and mostly stable wind flows. None of those natural resources will be adversely affected by TMT's operations. Of course, an astronomical facility has to include a building in order to enclose a telescope. So the existing of the building itself on land should not adversely and significantly affect the existing natural resources by its mere presence. Objection to an astronomical facility being built is contrary to the intention behind the resource subzone allowing for astronomical facilities. The recent Kila Kila decision addressing the facility at Haleakala analyzed that issue in a similar manner and accepted the placement within the previous astronomical use area. To further mitigate and reduce overall impact for the summit area, the university has committed to remove and decommission 3 telescopes at the higher, more sensitive Summit Ridge area. Exhibit A39 is the university's letter committing to decommissioning as part of this TMT project. This will clearly result in a reduction of existing summit area facilities and thereby reduce overall impacts and concerns about incremental growth in the astronomy precinct. The mitigation efforts here are also guided by the governor's 10-point plan and address future development, increased educational opportunities, and focus on cultural considerations during the university's management of the leased lands. The UH Board of Regents recently passed a resolution affirming its commitment to collaborative stewardship with those who share the university's belief that Mauna Kea can and should be a global model of synergy, balance, and harmony with indigenous culture, Pono stewardship, education, world-class scientific inquiry, and international collaboration. With award-winning management plans already in place, The university is committed to meaningfully increase education and involvement of Native Hawaiian students and all residents concerning astronomy, celestial navigation, and exploration. 7 years ago, the university filed this application for a CDUP to build the TMT on its leased lands. To say the least, the road has been long for all of those involved. One sentence. But the university's resolve has never wavered. We respectfully submit that the university has satisfied its burden of proof and ask that the board issue the CDUP. Thank you.
Thank you.
Yeah, got it higher this time. Thank you. John Pete Minot again for the University of Hawaii. I'd like to respond to 4 areas briefly. The first is the issue regarding the 2033 lease term and how the UH intends to deal with that. At present, the UH is seeking an extension of the lease. They're going through the EIS process, and we expect to go through that formal notice process shortly. So the 2033 lease extension issue is something that will be taken up in due course, and ultimately it's up to TIO to assume the risk to build if this is approved by the board. And the testimony from Mr. Stone was that they would assume that risk. So ultimately, that's not something that we believe should prevent the CDUP from being approved. The second point deals with the 5-year reporting requirement. There's some effort to conflate the annual reporting with the 5-year updates. And it's clear that the annual reports have been submitted by the university. In fact, the 2015 annual report actually covered previous 5 years, so it was pretty much cumulative. But when you look at the language regarding the 5-year updates, that is not a requirement that is mandatory. The language is permissive and states that it should be done every 5 years. Now, again, that's been covered in the annual reporting. So to do the 5-year updates before we have a final decision about the return of acreage and other issues is a bit premature. But the requirement for permissive should is in Exhibit A9 at page 7-65. In fact, Mr. Flores submitted a proposed finding of fact number 440 that acknowledged that that is a should and not a mandatory requirement. The other point raised by Mr. Flores dealt with the 2000 master plan and the design guidelines that were referenced in there. Again, those are conceptual design guidelines. They were never intended to be definitive and final for any project that would go in the new large telescope area. The language is clearly cited as a preliminary design concept at page Roman numeral 9-37. So it is not mandatory. The last point to consider very briefly is the obligation from the court's decision in Kapa'akai. It's clear that you have a full inventory of cultural practices pretty much on the summit region and in the astronomy precinct. The case language states, though, that you are to focus on the petition area. And when you look at the petition area here, there's no doubt we're talking about the 5-acre footprint and the 3-acre access way. So the findings that were submitted here addressed that petition area, and that information is already clearly articulated in the findings. If you opt and decide that you need to go beyond the petition area for some reason, then cultural practices that extend throughout the Summit Ridge area are also fully addressed and considered. And those impacts are addressed as well in the findings. So ultimately, we don't believe that the Kapa'akai analysis that you have to perform here is based on an insufficient record. We believe that there is more than enough cultural information through this 4-month-long process for you to review the inventory and survey of information related to that cultural process. Thank you.
I'm going to a completely new area, and most of my questions are addressed to university. Maybe TIO after that, but first of all, I have extensive questions for the university. Council wants to come up.
John Bennett.
The Pueo interveners in the first crossover, or the second crossover, I think it's the first crossover, came up with a list of suggested conditions. And I believe the TIO said these are okay conditions, except we don't want to pay for it. And all of those conditions involved matters relating to the education of at-risk children of Hawaiian and other ancestry in the Hilo and Big Island area. It included early entry into the university system. It involved the question of different subject matters that they were going to take. It involved issues of having cultural practitioners at Halepohaku, of having UH, Hawaiian Language College, have a footprint on the mountain along with the community college Hawaiian language program. The University of Hawaii didn't say one word about those conditions till today. Nothing in your presentation even addressed it, and neither did TIOs. So I don't know why I want to vote for this. I'm telling you right now, I live right in the middle of Keaukaha, and those at-risk kids are the people that we're looking after. And part of my extended family, the Hawaiians on Front Street, are related to me. You folks haven't addressed one iota of your fiscal energy to solving this problem. And it's right in front of you. You know it's a crucial issue. You haven't said anything about it. I'm greatly disturbed. I want to hear what kind of a commitment the university is going to make and how definite that commitment is. And I want to hear it now.
The university does accept and certainly appreciates the conditions proposed by Pueo. We do not object to the conditions that they have proposed. However, I will point out that those conditions do not have monetary terms, they do not have specifics. The ultimate goals and objectives are certainly worthy and something that the university can support. Now, when we're talking about how to fund that, again, we're talking about going through, the university's process to that involves their budget. If you're talking about the university itself funding it and whether they have any additional funds, certainly they do not at present have additional funds. If you're talking about making that a condition that you require TIO to come up with funds, that's certainly a question you more than likely can ask them. But again, these are not conditions that we disagree with.
Excuse me for interrupting you. I don't want to ask them. I'm asking you. I want to hear definitely what the university will assuredly do. Maybe you don't have the funds, but you got a big planning staff. You got all kind of access to all kind of funds from all over the world, grants, foundations, whatever. If this is a top priority, let's hear the specifics and let's hear it right now.
Thank you, Member Rohrig. David Lassner, President of the University of Hawaii. We did look at the conditions that were proposed by Pueo, and as Council said, we had no objection. The conditions didn't have numbers, but every single one of the aspirations that they stated were things that, I'm not sure where we would put the amphitheater. I think there was a level of specificity on some of their conditions that we didn't work through. But in general, the conditions as I read them were to collaboratively work toward the future development of Imiloa Uka. I love the idea. We have talked about developing a stronger cultural education presence at Hale Pohaku, and that's actually very exciting to us. The educational programs talked about development of a plan to implement and extend early entry programs. We are actively doing that now as we speak in these areas through programs such as early college, outreach programs into K-12 schools that we partner with, and we've also been partnering with Kamehameha as well as with the public schools. It's hard to write a plan in the context of the conditions of the CDUP, but we would be delighted to be working with Pueo and all of the partners across the university system and the K-12 school system and community groups to move this forward.
I think my concern is this has been stated by the university for a long time. This isn't the first year this came up. When I was in the Board of Regents in 1999, the same issue was being discussed at that time. And so here we are, this is 2017. And finally, the university or TIO people went down to Keaukaha and started talking to the elders down there. And the elders put this together in Pueo. And Bill Brown in particular, his testimony resonated with me. They want their kids to get a college degree. And I'm very disturbed, Dr. Lassner, that you folks, as a university, that you took it so cheap that you didn't say a word about this in your presentation, either in your first 10 minutes or in your rebuttal 5 minutes, not one word. And if we didn't bring it up, I have a strong feeling it would have passed into that same mist that I heard some of these practitioners talk about. So
I can only say these are things that were on our mind, and these are part of our activities independent of this telescope and the work we do on Mauna Kea.
In the Brown versus the Board of Education of Topeka, the school system was mandated by the U.S. Supreme Court to integrate the schools with all deliberate speed. 50 years has passed since that decision, and the deliberate speed hasn't been very fast. So I want to have some sense of certainty that you're going to work on it and you're going to do it right away, not 5 years from now. I want the university to commit you're going to do it now, and if you don't have the funds, you're going to find them, and you're going to do the various conditions that Pueo has, including putting Hawaii Community College Hawaiian Language Program on the mountain and Kahakaʻula Kolani Hawaiian Language College on the mountain. New folks didn't say anything about that either. The last time that this came around to the TIO and the leaders of Kahakaula went to talk to them, they got turned down. They got turned down. And I heard about it because I happened to be at the Kahakaula at that time. And so I want to know if they're going to go and you folks are going to get them up there right away and get this whole thing going with all deliberate speed.
I mean, there are a couple of ways I could go, and I mean, I think a lot of it has to do with an understanding, and I'd be glad to get together with you and talk about the work that we're doing as part of our commitment to advance the educational attainment of Native Hawaiian students, including but not limited to Keaukaha. But over the past 5 or 6 years, and I did not bring that data today, but we have increased the enrollment of Native Hawaiians. We have increased the success of Native Hawaiians, and that has been involving the spending of money. And frankly, you see the products of our work over many years here today, not in agreement with us on this issue, but I have to say I'm quite proud of our graduates.
It's been brought to my attention. It's been brought to my attention that we have to stick with what's in the record. And if my question didn't make that refinement, it has to be something in the record for us to consider it. So what's in the record that reflects that you're going to do this right away?
I don't believe there is anything in the record of this proceeding. There is quite a bit in the record of Board of Regents minutes and University of Hawaii strategic plans.
That's all the questions I have right now. I'll yield to other counsel if they have questions on this.
I still like the UHO. Annual Report to the Legislature. Act 132, 304A-2170. You are asked for all revenue. What I find missing is the revenue from the store, your legislature appropriations, if you get any, and interest earned and accrued. And the reason I'm asking this is that financially I'm trying to understand where you stand and how you've been managing the mountain. The other question I have pertains to what is the telescope's viewing rent when they charge other people to use their telescopes. And the reason I'm asking this question is how do I come to what is called fair market rent?
Right. Well, the rental for TIO is stated in the record, and ultimately in about 7 years it will be $1 million a year. So that will be, but
what I'm working off of is the University of Hawaii System annual report. And they were supposed to follow.
I will defer to.
Okay.
And I apologize.
What's in the record is finding the funding and to acknowledge what the funding is. No, this report is not in the record. But I need to. Well, can you ask the question?
Yeah. Okay. I can answer quickly into, so because I've looked at these lately, the revenue from the store is actually not collected by the University of Hawaii. That's collected by the Research Corporation of the University of Hawaii, which is a separate entity established by the state of Hawaii. Viewing time for telescopes is not a commodity that is bought and sold. So the telescope time is made available to the founding investors on a proportionate basis to the investment in the development and operations of the telescope. So you can't just go out and buy an hour of viewing time. It's simply not bought and sold in that fashion.
So you're saying on that, it's just the people that own the telescope are the only ones who use it?
And the University of Hawaii.
Right. And you get the viewing time for
We get
letting
a
them put
percentage
in-
of viewing time, which then is shared with the students and faculty of the University of Hawaii.
Okay, so the money from the store goes to another UH corporation?
It's not a UH corporation. It's separately established by the state of Hawaii. It's called the Research Corporation of the University of Hawaii.
Okay.
And you can Google it in statute. It
Does-
is administratively attached to the University of Hawaii.
So does the state get anything off of that?
I can't add more information. I'm not familiar.
Okay.
Sorry.
Thank you.
Try wait, brother. President Lasner, I've heard that the store raises in the neighborhood of $1 million a year on sales to the tourists at Halepohaku. We're talking about these conditions that Pueo proposed, where we would have a store at Halepohaku that would be an opportunity for Hawaiian craftsmen to sell their wares. And the question is, if that money got spent there, can that money be used to defray the expenses of the early learning program for the Hawaiian children? And that was kind of what the discussion was about. And the Halepohaku, as I understand it, is part of the leasehold of the university. So if the university has allowed the store to pay that money to the RCUH, why can't the university, as a lessee at Halepohaku, have a store for the Hawaiians, pay the money to the Hawaiian educational program? Is that a reasonable condition?
From my perspective, again, it's hard standing here at this point to actually convey my enthusiasm for the idea that Pueo presented regarding Imiloa Uka, as they referred to it. But I absolutely believe that calls for a re-envisioning of a number of things about how we educate visitors to the mountain. And I don't disagree with some of the testimony about our ability to do more. And I think that includes part of the visitor experience, including the store, the revenue, and other kinds of educational and cultural activities that could take place there. But again, I don't have a plan here today for you.
Can I just one more question? I just want to do a follow-up on your...
Just one more question, and then Chair will follow up. So you support something up there?
Absolutely.
All right. That's good enough for me.
So I just want to note with the comments in the record about Imiloa Uka, the countervailing concern about footprint and density and visitation on the mountain.
So again, we don't have a revised plan, but I think there's an opportunity to do more there, which could reduce traffic to the summit. Let me say unnecessary casual tourist visitor traffic.
I guess I also want to note that concern for Halepohaku as well, in the discussion about Imiloa Uka.
Bringing too many people up there. Yeah.
when I read the cross-examination of the Office of Mauna Kea Management staff regarding the removal of the kuahus and the lele from the mountain, it occurred to me that it would be an appropriate time to see what HAR 13-542 had to say about that, the Conservation District rules relating to the construction and taking down of structures on Mauna Kea. So it appears as though, this is just my observation, that nothing in that chapter relating to the Conservation District on Mauna Kea has ever fleshed out how you coalesce the rules that are in there with the pass rights. There's mention of the pass rights, and there's mention of Article 12, Section 7, but there's no deliberate process provided in the rules as to when a cultural practitioner is allowed to put up a kuahu or a lele and do it under the Constitution as an Article 12, Section 7 constitutional right, which would suggest that you don't have to follow Conservation District rules because the source of your putting it up or taking it down is in the Constitution and not in the rules. And there is a section, there is a section in the rules that specifically talks about that at 13-5- hang on. 42B, and then you got to scroll down to number 4, and it says, and I quote, use pursuant to Article 12, Section 7 of the Hawaii State Constitution. And this is an exception to when you have to get a permit to put something up or take something down. And my question to the university is, has the university ever passed any rules that articulate how this process takes place so that we accommodate both the Office of Mauna Kea Management in carrying out their job to make sure that people don't build things on the mountain they're not supposed to, but at the same time we honor the constitutional right of the Native practitioners under their pass rights to appropriately build or modify or take down or put. Ho'okupu doesn't mean you have to modify it. Ho'okupu can just be putting flowers, or you might put a message to your auntie who died. It can be all kinds of things. Ho'okupu is sometimes giving of a gift, a spiritual gift on some kind of a pu'u. So what has the university done since Ms. Kealoha's lele and all of her occasions when her kuahu had been taken down repeatedly? What have you folks done during how many years has this gone on, Ms. Shota? How many years has this gone on?
The first time it was taken was in 1998.
Okay, and this is 2017. I come back to the Brown versus Board of Education. You will integrate with all deliberate speed. Since 1998 to 2017 is quite a long time to figure out how to get it right so you don't have so much friction between the Office of Mauna Kea Management staff doing their work. Some of them are Hawaiians, and some of them are from Keaukaha. And they have trouble with them, and they're having trouble with other Hawaiians because other Hawaiians are the practitioners. So you have the Hawaiians against the Hawaiians on the mountain because the university and the DLNR, us, because we don't have any refinement of how you meld these two things together in these rules, the 13-5-24B. Do you have any comments about that, Mr. Minot?
Sure. I will try to answer that to the best of my ability here. In the first instance, the Office of Mauna Kea Management staff views the placement of an object or a structure pursuant to the rules governing the placement of a structure in a conservation district area. And that would require, in the first instance, a permit. Now, the way that plays into this constitutional protection that you're talking about is clearly there's the right to reasonable regulation by the state. As the law currently exists, if somebody wants to install a structure, they're required to go through this same CDUA process for a broad structure type installation on the mountain. Now, clearly there are some efforts to handle the lesser lay offerings and sort of the organic materials which are typically allowed to be placed wherever the person wants to place it on the mountain, and that should not be a problem. But when you're talking about constructing an ahu or something that has a significant sense to it, a sense of being a rock or a few rocks that ultimately can be defined as a structure, the only thing the university can look to right now is the law that requires in this area to go through the permit process.
And those are the rules that I'm referring to, isn't it? It's the very set of conservation district rules that I just referred to.
The structure.
13-5-24B. That's where it's located. Isn't that correct?
Yes, it should be.
Okay, and so I still raise the question, why haven't we fleshed out the differences between the constitutional pass rights? If it's a right, does that mean you have to get somebody else's consent? I think this is where the rub is, that the practitioners don't feel that they have to go and get consent from the Office of Mauna Kea Management before they want to do their blessings at their ahu or at their lele. And so we have this conflict, and it's between Hawaiians. People got different jobs. So how are we going to resolve this, and how are we going to resolve this promptly to take away this sore that we have on the mountain? Because every time somebody takes down a kuahu, it opens the wound again. And we just perpetuate the angst between the native practitioners and the staff of the University of Hawaii on the mountain, who just happen to be Hawaiians as well. So how can we resolve this?
In 2009, the university was given legislative authority to develop rules, and as you correctly point out, we don't have them today. The Office of Mauna Kea Management, working with Kahukumana and the Mauna Kea Management Board, did develop draft rules. Those were not moved forward, and while I don't believe it's part of the public record of this proceeding, we have publicly noted that the governor asked us not to send those rules forward pending other issues around the 10-point plan. So those draft rules, which cannot go out to public hearing without the governor's consent, are still sitting with the University of Hawaii.
Sorry.
I'm going to yield to, well, unless Ms. Pichota, do you want to answer that? And then I'm going to yield to Board Member Ewan.
Okay, I just wanted to clarify something. What was through cross-examination, at least my cross-examination of the OMKM director, Stephanie Nagata, and Wallace Ishibashi, what I discovered was that they weren't looking at a rule. They were citing the definitions. It's definitions of land use in the rules. But in that definition, Native Hawaiian things are practices. It says subject to Article 12, Section 7. So those were exemptions for getting the permit. You know, this idea of a land use means altering these things. But if you look in the definition, you'll see that there's an exemption to that regarding our stuff. And what I just wanted to say was, it's our position that it is not the university that should be doing this. It's the BLNR that should do that Kapakai analysis for exactly this reason, so that the agency, the university, you're still the overseeing agency. It's a conservation district. And while the university has a general lease to use it, they don't have a right to change its use, which is conservation, historic district, so on and so forth. So that's why we hold the position that BLNR needs to take a more affirmative action in identifying these rights and perhaps negotiating the terms of those, because you guys only can regulate us. That's our position. So that's what I just wanted to add.
Okay, please, we're going to respect the process. Thank you. Chris, your question is next, Chris. He's part of the party that was being asked the questions. He's part of University of Hawaii. Yeah.
Good.
Yeah.
Mr. Minot. So, this, okay. I don't know. Am I on? Okay, good. So this question of ahu is out there, and it will exist. I think it exists independent of the question before us here of whether a permit should be granted or not to the TMT. And I don't think any of the questions were meant to imply that there's some kind of a right to put ahu in the middle of the road or on a construction site because you disagree with it. But is the university willing to work on developing a simple process for like a one-day, one-stop process for getting a permit to put up an ahu?
Well, if you're referring to the two existing ahu on the roadway, it's our intention that those will ultimately need to be moved so that trucks can traverse the roadway. And so there is a process that we think we can establish either voluntarily or through conditions whereby the parties can work together to relocate it or set it aside in a reasonable area.
Well, actually, my question was really, first of all, on the assumption that there is no right to build an ahu in the middle of a road or on a construction site where somebody has a permit to build, where if and when somebody has a permit to build. But there are people that want to put up ahu and other kinds of markers or monuments, personal or group or whatever. And it seems to me that that could be accommodated through some very simple permitting process. Is the university willing to work on that?
Oh, absolutely. And I think one of the goals of the draft rules that are currently on hold is to work towards that effort, yes.
All right, that's all I have.